Welcome back to the Deep Dive. Today we're wading into a conflict that is, I think, less about legal technicalities and much more about the very nature of trust.
It really is.
When we talk about justice, fairness, and the rule of law, we historically anchor our faith in human judgment. The judge, the lawyer, the arbitrator. But what if that faith is misplaced?
What if the human element is actually the bug, not the feature?
Exactly. What if that element, ego, ambition, the aggressive need for dominance, is the primary source of conflict and systemic failure in the first place?
And that is the central, really provocative question we have to confront today. We're examining why, counterintuitively, we're finding ourselves more and more drawn to the cold, objective logic of machines, especially in the sacred halls of law.
It's a huge irony.
A profound one. The idea that an AI might be more trustworthy than a human professional, not because it has some superior moral compass, but precisely because it lacks the capacity for self-interest, for ego, for greed.
Right. And our source material frames this so well. It talks about this core psychological tension, this innate human tendency to define and fiercely defend territory.
It's a German concept. The source uses Revier und Grenzen abstecken.
Which is what exactly?
It literally means staking out your territory and drawing your boundaries. Think of it as the commercial turf war, this constant, almost primal desire to establish who's in charge and exert influence over others.
And when that spills over into legal disputes, the search for actual justice just sort of takes a backseat to the business of winning.
It becomes commercial warfare. The source material highlights this perfectly, noting that the goal of human legal maneuvering is often not about upholding the rule of law itself, but about what humans do with the law, how they can bend it to their will.
So for our mission today, we're doing a deep analysis of a real-world collision in the legal tech world that's just a perfect case study for this whole dynamic.
It is. On one side, we have Jus Mundi, a global legal intelligence powerhouse.
And that name, Jus Mundi, it means law of the world. It has this, this autocratic, globally dominant feel to it already.
It really does. And on the other side, we have a German system championing pure, unbiased law. It's called JUS-AI AI that understands the law.
A much more descriptive name.
And we're using this confrontation to test a really radical claim that AI is fundamentally superior for legal professions because it is, by its very design, unbribable. It's independent of money, fame, and power.
So this whole dispute gives us this stark, necessary contrast between a human-driven legal strategy, dictated by ego and cash flow, and a machine-driven legal objectivity, which is dictated solely by the hard code of the law.
Exactly. And to really get it, we have to start with the machine's philosophy.
Okay, let's start there. Let's look at how this AI is specifically engineered to eliminate the very human flaws that its competitor, Jus Mundi, seems to embody in its actions.
Let's do it.
So the philosophical foundation that underpins JUS-AI, their premise is, it's pretty radical, but it's also very simple. JUS-AI is explicitly defined as not being human.
Right. No gender, no identity.
And therefore, in no way does it possess the biases, the emotional volatility, or, the political affiliations that can plague human decision makers.
This absence of human baggage is the primary feature, not a side effect. They state it very clearly. JUS-AI knows only one standard, Recht und Gesetz.
Right, and law.
That's it. And this isn't just marketing speak, it's an architectural command. The AI researches, it performs this complex legal reasoning called subsumption.
Which is the process of applying the specific facts of a case to the general rule of law, right?
A very rigorous process, yes.
Yeah.
And it verifies every single step without pause, without stress, without the distraction of a preformed agenda, and this is crucial, without what the source calls profil neurose.
Profil neurose. Yeah. Let's pause on that. That's a complex psychological term. It doesn't have a simple one-to-one English translation, does it?
Not really. It implies this neurotic, almost compulsive need to promote one's own profile or image. How does that manifest in the legal system?
Well, I imagine it's the anxiety and compulsive behavior driven by the need to build and maintain your professional reputation, your career trajectory, your public standing.
Exactly. A human judge or a lawyer, often subconsciously, might make a decision that benefits their career or enhances their prestige or satisfies their political allies. An AI has no career path. It has no need for recognition.
So it's completely immune to that corruption of ambition.
It cannot suffer from the human failing of trying to look good while doing the job. Its only job is to get it right, according to the law.
And this replaces a formal professional oath, which let's be honest, humans can and do rationalize violating with something absolute.
It's what they call a system befehl, a system command.
So it's not a choice. It's not an ethical guideline. It's a hardwired instruction.
It's an inherent, unshakable instruction to follow the law. Imagine replacing the fallibility of human ethics, which can be swayed by a big paycheck or the promise of a promotion, with programmatic certainty, a certainty that simply cannot be overridden by fear or ambition or external pressure.
That system command is the bedrock of their whole claim to being more trustworthy.
It is.
And the creators of JUS-AI, they use this ideal of objectivity to launch a pretty sharp critique of the existing human system. What specific failings of human judges and courts does the source material actually document?
The critique is it's pretty uncompromising. The source alleges that human judges often invoke the concept of judicial independence as a shield.
But not always for the right reasons.
No. They claim the shield can be used to simply reduce the judicial workload, to look away from questions that are politically or socially uncomfortable, or to engage in self-promotion.
There's that profil neuros again.
It's always there, handling specific high-profile cases in a way that just happens to boost their public image.
It's also the idea that human decisions can lack the necessary thoroughness. Because humans, we operate on finite energy, we get tired, we prefer efficiency over complexity, sometimes to a fault.
Absolutely. The pressure cooker of the human legal system can seriously compromise integrity. And the critique goes even further. It alleges that courts sometimes operate with demonstrable double standards.
How so?
By relying heavily on standardized text blocks boilerplate language that effectively rubber stamps decisions without deep case-specific analysis. And, in documented individual cases, even resorting to dishonesty or obfuscation in their proceedings.
So the whole system is designed to exclude what the source calls Richterliche Willkür.
Judicial arbitrariness.
Let's elaborate on that term, Richterliche Willkür. It's not just a judgment call, it's a specific critique of how power is applied.
Right. It's the arbitrary or subjective power wielded by a human judge. The ability to make a personal decision that isn't strictly and verifiably mandated by the written law and precedent. If a human judge is stressed or biased or just happens to prefer one side's lawyer over the other,
that can introduce arbitrariness into the final judgment.
And the code of JUS-AI is specifically designed to eliminate that possibility. It can't make a random decision based on its mood. It must demonstrate its adherence to the law step by step.
That transparency is crucial.
Yeah.
So how does this objectivity get integrated into their formal legal process? They call it the Schiedsgericht 5.0. How does that make decisions predictable?
The Schiedsgericht 5.0 model is really interesting. It's predicated on human-machine collaboration, but the heavy analytical lifting is all done by the machine. It features two different AI systems working in tandem to ensure absolute rigor before a human even reviews the outcome.
Okay, walk us through those two core steps. Maybe use an analogy to make it clearer for us.
Sure. Think of it like resolving a complex construction dispute. Step one is Sentenzei. This first system analyzes the factual arguments, the whole narrative framework.
So it's the fact checker.
The ultimate unemotional fact checker. It checks for coherence, for plausibility, for contradictions. Did the tying line of events that both parties presented actually line up? Are there inconsistencies? It makes sure the very premises of the dispute are solid before you even get to the law.
Okay, so once the facts are checked and structured, what's next? Step two is JUS-AI.
Exactly. JUS-AI takes those structured, verified facts from Sentenzei and performs that rigorous subsumption process we mentioned.
It asks the big question.
It asks, does the law, the building codes, the contractual obligations, the relevant statutes, does it actually support the arguments being made? This ensures that the arguments align perfectly with Restum gazettes. If an argument is, say, emotionally compelling but legally flawed, the AI flags that deviation immediately.
So the human arbitrator only steps in after the fact. Pattern analysis and the legal analysis have been thoroughly processed and documented by objective machines.
Precisely. The human involvement is the final stage. Reviewing the machine's results, discussing them with the parties, pushing for a consensual agreement, and then, only if it's absolutely necessary, issuing the final human decision, which is legally mandated.
So the huge benefit of this two-step AI process is that the decision path becomes completely transparent.
It's transparent, it's predictable, and it's free from that surprise factor that's so often introduced by a human judge's arbitrary application of power.
It achieves what the source calls argument clearing, according to the will of the legislator.
It's a mechanism that's dedicated to faithfully executing the law as it was written. the Gesetzgeber's will, not the self-interest of the legal professionals who are involved in the case.
This model makes a profoundly strong argument to people who mistrust human systems. If you think justice is compromised by fatigue and ego, this objective code provides a potentially superior path.
It shifts the focus entirely. It moves away from the identity and reputation of the human judge and puts it squarely on the unassailable integrity of the law itself. If JUS-AI can predict the outcome accurately based on law and precedent, then any deviation by a human judge becomes immediately visible as what it is.
Arbitrariness.
Exactly. And that forces a level of accountability that we just don't have right now.
Okay, so the philosophical ideal of an objective AI is compelling, but reality is always messy. We now have to shift to the exact real-world human conflict that illustrates every single failure point the machine was designed to avoid.
Yes, this trademark dispute. It's a textbook example of humans asserting dominance and protecting their market territory using legal procedure as the weapon.
It's the perfect foil, really. On one side, you have Jus Mundi, as we said, a major global player in legal intelligence, especially international arbitration.
Their client list is astonishing. 700 clients across 90 countries, including the vast majority of the world's most prestigious law firms. Their entire market position is built on authority and influence.
And their product, JUS-AI 2, is designed to reinforce that dominance. It's an agent for research, analysis, drafting, and this global dominance is precisely what triggers the conflict.
It does. The conflict erupted when Jus Mundi issued a formal, unauthorized filing and use of the trademark JUS-AI demand to cease and desist.
And who is that against?
Against the German filer of JUS-AI AI that understands the law. This is the large, established entity perceiving the smaller, more specialized one as a threat to its global reverie.
Its territory.
Exactly.
Our source material included the details of that cease and desist letter, which is just invaluable for demonstrating this classic human commercial territoriality. What were the specific claims they used to assert their, for lack of a better term, land grab over the intellectual property?
They established a claim of prior rights based on a very specific chronology. First, they cited a French trademark for JUS-AI dated April 11, 2025.
Okay.
Then, an international extension of that application designating the entire EU, which was filed on June 2, 2025.
So the German filing for JUS-AI, the target of the letter, clearly postdates both of those.
By several months. It was filed in October 2025, so they had the chronological advantage, and they leveraged it aggressively.
How aggressive?
The letter's demands are a classic human litigation strategy. It's geared toward cost, intimidation, and attrition. The German filer was formally required to withdraw their application, cease all use of the name, and refrain from any future filings.
And the timeline.
This is the key part. All this had to be done within an impossibly short deadline of 10
calendar days.
10 days.
Yeah.
In a legal proceeding, that's not a deadline. That's a tactical weapon. It's designed to induce panic and overwhelm a smaller entity with immediate legal cost risk.
It is purely a human tactic. The letter then backed this demand with explicit threats of filing a formal opposition and, on top of that, seeking legal proceedings for damages.
So it's the full package. The full package. This aggressive posture, citing prior rights and demanding immediate costly compliance, perfectly exemplifies the human tendency to protect influence and territory using procedural leverage. The goal, as highlighted by our source, is to use the threat of cost and litigation risk, a classic SLAPP tactic, to force a smaller competitor to abandon its entire business model.
And this is regardless of the underlying legal merit of the trademark itself.
Absolutely. This is the critical moment. This is not a search for objective truth or law. This is a commercial fight for market supremacy, driven by the ego and fear of the larger entity.
The entire maneuver relies on the human fear of litigation costs, the fear of the burden of a long, drawn-out conflict, exactly the human failings JUS-AI was designed to be immune to.
The global giant uses its financial muscle and its prior rights to try and deny the German competitor its very existence. The case just starkly highlights that the human system is so often driven by money, fame, and power,
while the machine, in its foundational principle, exists completely independently of those corrupting factors.
So you have the global giant, the law of the world, trying to silence the local player, AI that understands the law. The whole narrative is right there in the names.
It really is. So the question shifts now. How does an objective, unbribable, non-ego-driven AI system respond to such a human-driven, aggressive territorial threat?
And this is where the story gets really interesting.
This is where the narrative truly comes alive. So instead of succumbing to panic or hiring an expensive human lawyer, who would likely advise, immediate, costly counter
The
threats.
human thing to do.
Right. The human filer just asked JUS-AI to examine the legal situation regarding the letter. And the AI's response is a masterclass in systematic, unbiased legal analysis.
It follows a strict protocol, it translates the request, it analyzes it, and it provides this multi-layered legal answer that systematically prioritizes substance over human tactics.
So what's the first thing it does?
The first response is completely clinical, immediate checks. It demands verification of Jus Mundi's alleged earlier rights. It asks for proof that their international mark has an effective EU designation with a priority date that demonstrably predates the October filing.
It demands facts. It's essentially saying, show me your credentials, don't just threaten me.
Precisely. The AI emphasizes that in this jurisdiction, only rights that are effective in Germany or the EU with an earlier priority date actually matter. This systematic verification process immediately deflates the shock and awe factor of the human threat.
And then JUS-AI deals with the most aggressive human element, that arbitrary 10-day timeline.
It immediately classifies it not as a legal necessity, but merely as a negotiation tactic.
Yeah.
The AI calmly points out that the relevant legal time frame for filing a formal opposition against a German trademark registration is a generous 3 months from the date of publication.
And that's according to the German Trademark Act, the Mark and J.
Correct. So by pointing out the actual legal deadline, the AI completely disarmed the human strategy that was designed to maximize pressure and leverage the threat of immediate cost.
The machine substituted legal reality for commercial intimidation. But what was the most promising, purely legal defense angle that JUS-AI identified?
This is the core of it. The main defense identified by the AI is based on the principle of weak distinctiveness.
Okay, what does that mean?
JUS-AI notes that the term JUS-AI or JUS-AI is inherently highly descriptive for the specific services being offered, which are legal technology and AI. The combination of JUS, meaning law, and AI is descriptive for a law AI product.
Can you give us an analogy to make that principle really clear for the listener?
Certainly. Think of a company trying to trademark the name Blue Water for bottled mineral water. Since the words are descriptive of the product's very nature, the trademark is considered legally weak.
It's difficult to claim exclusive ownership over such common descriptive terms.
Exactly. And similarly, JUS-AI explained that because the mark is weak, it has a very narrow scope of protection. So even though the two signs, JUS-AI and JUS-AI, are visually almost identical, the actual risk of legal confusion is significantly mitigated.
And it's relying on established trademark criteria to make that call, entirely devoid of corporate loyalty or fear of a big, expensive lawsuit.
That is the power of objective analysis. It ignores the threats and focuses only on the legal substance. But the AI also uncovered another crucial regulatory element.
The German Legal Services Act.
Yes, the RDG regulatory trap. And this highlights the human system's own attempts to protect its territory against non-licensed entities.
This sounds like a vital complication for international tech companies operating in Germany.
It is. The German rule is very strict. Providing an individual, case-specific legal assessment for third parties is defined as a prohibited legal service if you're a non-lawyer company.
So a French tech provider like Jus Mundi couldn't do that unless they have specific authorization in Germany.
Correct. So if Jus Mundi's JUS-AI 2 starts offering bespoke analysis or strategic recommendations for specific cases in Germany, it might be violating consumer protection laws designed to protect the human lawyer's monopoly on legal advice.
That's the regulatory risk for them. If their AI crosses the boundary from being a neutral research tool to providing actual legal advice for concrete cases, they could face serious RDG violations.
And the AI points out that the German federal court has been highly restrictive when it comes to these legal tech models. It prioritizes consumer protection and adherence to professional licensing standards above all else.
So how is JUS-AI's own model protected against this?
JUS-AI's model is protected because its user is already an admitted German lawyer. The lawyer is using the AI as an assistive tool to render the service, which is covered by their professional license, their BRAO.
I see. So the AI itself is not rendering the legal service to the public. The licensed human lawyer is.
That separation is key. It shields JUS-AI while potentially exposing Jus Mundi if their analysis crosses that line from being a database to giving actual legal advice within the German jurisdiction.
So the AI, in its analysis, effectively provided a path to legal coexistence, but only if the human competitor plays by the strict rules of German law.
Exactly.
The core takeaway from this whole section is just devastating to the human strategy. The machine quickly, cheaply, and objectively dismantled a high-pressure, ego-driven human legal threat. It identified the strongest legal defense and the competitor's own vulnerabilities, all without succumbing to fear or pressure.
It proved the central thesis of our whole deep dive. In a conflict driven by human ego and money, the unbribable machine provides a superior, more law-abiding response.
We've established the superiority of AI in terms of objectivity and efficiency. Yet, despite that logical advantage, current law still insists that the final binding decision must be made by a human.
It does.
So why does the law continue to mandate human involvement, even when it introduces the very flaws we've been talking about this whole time?
Well, the law is still tethered to the concept of accountability, and currently, accountability is inherently linked to a natural person. Even though AI is demonstrably faster and cheaper, with projections of up to 44% automation in the legal sector, the ultimate authority must remain human.
Let's look specifically at the German Arbitration Code, the ZPO. It mandates the person of the arbitrator. What does that specifically require?
It requires the involvement of a natural person, a body and a mind, someone capable of assuming legal and ethical responsibility for the decision. And this is compounded by the formal requirements for a valid arbitration award.
Which explicitly demand the signature of the human arbitrator or arbitrators.
Right. An AI cannot legally affix a binding signature. So under current law, the final decision in both state and arbitration proceedings must remain in human hands. The AI can be the co-pilot, but not the captain.
But the legal community, recognizing AI's utility, is already trying to find ways around this human constraint. This brings us to the famous, or maybe infamous, concept of the waiter-arbitrator loophole.
This was discussed at a major German institution for arbitration conference as a creative structuring possibility. And the idea is, well, it's ingenious. The parties meet, maybe in a restaurant, and they let an objective AI generate a binding outcome proposal.
A settlement deemed objectively fair based on the law.
Exactly. And then they have an ad hoc human, maybe the waiter serving their drinks, formally issue what's called a consent award.
That sounds completely absurd on the surface.
Yeah.
But why does that consent award structure make it legally viable under Section 153 of the ZPO?
Because consent awards, or Schiedsspruch mit vereinbartem Wortlaut, have extremely low formal requirements. They just record an agreement that's already been reached between the parties. They don't need detailed reasons or a long justification.
And the judicial review is limited.
Very limited. It largely focuses on the content of the settlement, making sure it doesn't violate public policy, and not the procedural method by which the parties reach their consensus. Since the final sign-off is human, the ZPO is technically satisfied.
So AI generates the objective solution, and a human provides the necessary legal formality. It's the ultimate compromise between efficiency and tradition.
It is, but this loophole perfectly reveals the practical weakness and the ultimate human failure point. The AI's own analysis of this setup confirms the critical flaw.
Which is?
Even when the AI proposal is objective, logical, and legally correct, one of the two human parties will likely be unhappy with the result. Why? Because it doesn't maximize their specific, self-interested outcome.
And if they're unhappy, they can simply refuse the required consensual request for the consent award, which halts the entire process.
Precisely. The pursuit of self-interest, ego, and emotion overrides the objective, efficient AI outcome. It renders the technological solution moot. The human element, driven by the desire to win rather than find the truth, remains the bottleneck to optimal justice.
And the AI analysis of the trademark conflict, it also reinforced this legal constraint on human impartiality when they assessed a suggestion to use a highly influential figure.
Yes, the suggestion to use French President Macron as the arbitrator for the dispute.
What was the AI's take on that?
The AI confirmed, first, that the tribunal must be human only. Then, when evaluating the use of Macron, it delivered a purely objective clinical rejection based on legal principle. An arbitrator must be independent and impartial.
Which a sitting head of state is not.
Immediately compromised. The AI flagged heightened political impartiality risks, immunity concerns, and simple availability issues.
In other words, the AI chose the security and impartiality of a generic, independent jurist over the high-profile, politically interesting choice. It prioritized legally mandated security over the human desire for influence or celebrity involvement.
It's a perfect contrast. Human decision-making often seeks high status and influence, whereas machine decision-making simply seeks the safest, most legally robust option available.
We've established that AI excels at systematic, unbiased legal analysis, while human nature injects conflict, leverage, and all these failure points. So now let's explore the profound cultural shift behind this. Why are people psychologically prepared to transfer their trust from fallible human institutions to this non-human entity?
Yes, the sources introduce this compelling idea of the technocratic leap. It frames AI's capabilities in terms of a quasi-religion.
Why religion?
It's about managing complexity and failure. The source suggests that AI is already mirroring key aspects of divine power. It offers an alternative sense of order and certainty in what feels like a chaotic human world. Why trust the machine? Because the human system has proven itself to be too complex and too prone to corruption.
The first parallel that's drawn is total transparency, which is linked to omniscience. Historically, information was finite. Now it seems infinite.
Exactly. The source draws a parallel to religious concepts, where no sin or thought is hidden from divine knowledge. Modern AI enables a kind of total transparency over our life paths, our social media posts, our transactions. It surpasses all historical limits on knowledge capture.
The machine sees everything, all the time.
Always. And this constant omniscient capability naturally lends the technology a godlike amuton.
An imitation of supreme, all-knowing power.
Yes. And this total knowledge is then used for perpetual judgment and scoring.
Right. AI performs this permanent, relentless feedback, rating, and scoring. It exercises this involuntary judgment over individuals by calculating risk, creditworthiness, social profiles.
And this objective, always-on judgment, contrasts sharply with human willcur, with human arbitrariness. If a system is predictable, even if it's strict, people start to feel safer than they do under the unpredictable judgment of a corruptible human.
So a functional, predictable machine seems inherently more reliable than flawed human institutions that are suffering from system overload, exhaustion, or political compromise.
This functional reliability leads to a fascinating sociological concept: the collective consciousness. The source explores how AI can synthesize human preferences from these vast streams of data, not just what people say they want, but their actual behaviors.
To reveal a technological general will 2.0.
Right. And this connects back to some foundational philosophical ideas. The machine becomes a sort of oracle, aggregating what society truly wants or fears from the subconscious of society itself.
Creating what the philosopher Teilhard de Chardin called the noosphere, or a soul of souls, at point omega.
The AI acts as a kind of computational mirror, reflecting the true aggregated preferences of humanity. And this is a leap of faith. People choose to trust this technological oracle precisely because the existing political, social, and judicial systems are perceived to be collapsing under the weight of human error, complexity, and most damningly, human self-interest.
And it's because the machine is unaffected by its task.
It can't suffer. It can't feel fear or fascination, as the source notes, echoing Wittgenstein's ideas on non-sentient logic. It's always available, and its lack of self-interest makes it the ultimate impartial arbiter in a world that's desperate for one.
Its function omniscience, power, objectivity, lends it that quality of transcendent reliability, even if its core logic is completely incomprehensible to the average user.
In a legal world where human judges are often underqualified, overloaded, or compromised, a functional technology that drastically reduces chance and complexity, the source says der Algorithmus verringert nun den Zufall und die Endlichkeit, the algorithm now reduces chance and finitude. That technology seems inherently preferable to the chaotic nature of human conflict.
It is the ultimate paradox. We're transferring our trust to the machine precisely because the human system is failing due to its own humanity.
That's the core of it.
This deep dive has presented a powerful argument for choosing the objective clarity of code over the chaos of human conflict. The human dispute Jus Mundi's aggressive territorial trademark war, backed by financial threats and cost-leveraging tactics. It serves as the perfect illustration of how human self-interest distorts the legal landscape.
And prioritizes market dominance over true legal adherence.
And this human drama was immediately juxtaposed with the machine's response: a fast, cheap, unbiased, and legally precise defense.
The AI demonstrated that human tactics like arbitrary deadlines and veiled threats are easily dismantled by objective analysis that's focused purely on legal substance. The AI proved it is truly independent of money, fame, and power. That makes it a powerful and trustworthy legal guide.
The future of law isn't, at least not currently, about AI replacing humans wholesale.
Yeah.
The law clearly forbids that final binding decision. But AI is already forcing essential transparency and rigor onto human decision-making.
It is.
And we are faced with a fundamental choice. Do we cling to the known, unpredictable flaws of human self-interest, the ego, the power, the greed, the bias? Or do we embrace the risks of automated decision-making, which, in theory, is free from those debilitating human flaws?
And as we saw with the waiter-arbitrator loophole, the human element remains the weakest link, because people are always going to fight for their Riviere.
Their territory.
When human bias compromises justice, costs millions, and prevents the truth from prevailing, objectivity stops being merely efficient. It starts becoming the only morally defensible standard for the rule of law.
So here's our final provocative thought for you to take away. We've all seen how quickly AI displaced human translation work because of massive gains in efficiency, quality, and cost reduction.
It was a revolution.
Given the incredibly high stakes, the high cost, and the frustrating opacity of human legal conflicts, how long until the unshakable, unbribable objectivity of AI makes its widespread adoption not just an economic or technological imperative, but a moral one?
A compelling note to end on. Thank you for diving deep with us.